There will now be an opportunity for silent prayer or meditation. Please be seated. Order. Honorable members, order, honorable members. Hlala phansi. Sit down, honorable member. On behalf of the presiding officers, I wish to convey our heartfelt condolences to the family, his political party, and friends of the Honorable Prince M.G. Buthelezi, who passed away on Saturday, the 9th of September 2023. The House will schedule a condolence motion in this regard at the appropriate time. May we stand and observe a moment of silence in memory of the honorable member and all those who have departed. Thank you. Honorable members, I should also inform the House that the Speaker and the Chairperson of the National Council of Provinces, together with leaders of political parties or their representatives, will visit the Buthelezi homestead on Wednesday, the 13th of November 2023. I thank you. Order of the day, September. You know why? November is my birthday. Thank you very much. Honorable members, the Secretary will now read the order of the day.
Consideration of recommendation for the removal of Advocate B. Mkhwebane from the Office of the Public Protector in terms of Section 194(1)(c) of the Constitution.
Honorable members, on the 3rd of December 2019, the House adopted rules to provide for procedures to give effect to Section 194 of the Constitution pertaining to the removal of office bearers in institutions supporting constitutional democracy. The report of committee on Section 194 inquiry, established in terms of National Assembly Rules 1 to now, is now before the House, and after the debate, the House must take a decision on the recommendation of the committee that the Public Protector be removed from office. At this point, honorable members, I have a list of speakers, and I now invite the chairperson of the committee, the Section 194 committee, Honorable Richard Gyangi.
Honorable Speaker, the Deputy President of the Republic, members of the Executive, members of Parliament, members of the media, fellow South Africans, to echo the words of the Constitutional Court, the National Assembly and by extension Parliament is the embodiment of the centuries-old dreams and legitimate aspirations of all of our people. It is the voice of all South Africans, especially the poor, the voiceless, and the least remembered. It is a watchdog of state resources, the enforcer of fiscal discipline, and cost effectiveness for common good of all of our people. It also bears the responsibility to play an oversight role over the executive and state organs and ensure that constitutional and statutory obligations are properly executed. Parliament is the mouthpiece, the eyes and the service delivery ensuring machinery of the people. No doubt, it is an irreplaceable feature of good governance in South Africa. The public project is established by Section 181A of the Constitution as one of the institutions set up for a very important purpose of supporting and strengthening our democracy. The Constitution, in unambiguous terms, provides that the public protector is independent and subject only to the Constitution and the law, and it must be impartial and exercise its powers and perform its functions without fear, favor, or prejudice. Moreover, the Constitution enjoins organs of state through legislative and other measures to assist and protect the public protector, to ensure its independence, impartiality, dignity, and effectiveness. The public protector, like other Chapter 9 institutions, is accountable to the National Assembly. Accountability is the cornerstone upon which the Constitution is built. It is the pillar that drives our constitutional dispensation. Accountability, together with the responsiveness and openness, are the cornerstones of our democracy. And all of these values entrench a culture of justification and explanation of one's actions. The Supreme Court of Appeal explained, to ensure a functional, accountable, constitutional democracy, the drafters of our Constitution placed limits on the exercise of power. Institutions and office bearers must work within the law and must be accountable. Put simply, ours is a government of laws and not of men or women. The committee thus found itself in an unenviable position, one that every South African would hope is never repeated, where it had to hold to account the very person appointed to investigate impropriety and improper conduct in state affairs. The charges against Advocate Mkhwebane, based on the grounds of misconduct and incompetence, were serious and related largely to matters in which all South Africans have an interest and which impacted us all. These included alleged misconduct in respect of the reports of the South African Reserve Bank and the Free Dairy Project. In addition, there were serious charges alleging misconduct and/or incompetence and relating to the management of internal capacity and resources in the PBSA, the prevention of fruitless and wasteful and/or unauthorized expenditure in legal costs, failure to conduct investigations independently and impartially, and/or deliberately avoiding making findings against or directing remedial action against certain public officials while deliberately reaching conclusions of unlawful conduct and imposing far-reaching remedial action in respect of other officials. After the former speaker determined that the motion was in order, it was referred to an independent panel for a preliminary assessment. The panel comprised of the retired Judge Kabinde, Advocate Tsebenza SC, Advocate Deval SC, who conducted this preliminary assessment. On 16 March 2021, this House agreed to conduct an inquiry into Advocate Mkhwebane's fitness to hold office on the grounds specified in the motion. Since the dawn of democracy, this committee is the biggest committee ever to have been established, with each of the 14 represented parties in the National Assembly having voting power. This speaks to the importance and interest in the matter we were charged with. The inquiry was embarked upon without a blueprint or precedent to guide us, but we're unanimous in our understanding that our role entailed a fact-finding exercise to establish the veracity of the charges contained in the motion and whether those facts establish misconduct or incompetence as defined. We placed no blind reliance on the report of the independent panel, aware of the limitations of that body. We were at all times acutely aware that the committee had to discharge its function with reference to its constitutional purpose by providing this House with sufficient information to determine whether the grounds as alleged have been established. I have no doubt that the committee has established established on the facts that Advocate Mkhwebane has indeed misconducted herself and is incompetent. She is therefore not fit for this esteemed office which she has been entrusted. Indeed, our report is detailed and described with reference to the facts that we adduced why this is the case. Ours is not an inquiry which rubber-stamped the findings of the independent panel or the courts. On the contrary, we had hundreds of hours of testimony and were seized with copious documentary evidence. Where we have established misconduct or incompetence, we are confident that Advocate Mkhwebane did not raise any valid defense for a conduct to sway us. In fact, the inquiry unearthed even further examples of misconduct and incompetence that, had this committee not adduced evidence in the manner that it did, would never have come to the fore. The committee proceedings were guided by the rules of this National Assembly, our terms of reference, the directives issued by myself as chairperson, powers, privileges, immunities of Parliament and Provincial Legislative Act of 2004, but most importantly, the supreme law of the land, the Constitution. The committee process was inquisitorial in nature. We agreed to utilize the services of evidence leaders to assist and empower us by presenting evidence and putting questions to Advocate Mkhwebane. From the onset of the inquiry, Advocate Mkhwebane indicated that she was participating under protest, but was eager for a version of events to be heard by the public. But as it were, the committee was denied the opportunity to hear direct oral evidence due to circumstances beyond its control. She never answered the many questions which the committee put to her on the substance of the matters before us, instead adopting an adversarial approach where she maintained that the process has been inherently and irreparably unfair and biased and the outcome predetermined. The committee dealt with several procedural objections and was faced with various obstacles which interrupted and affected our ability to carry out our work. Indeed, the journey was not easy. There were many off-ramps, but we soldiered on, determined to fulfill our constitutional obligation and not to be held to ransom. I have no doubt that the committee has carried out its functions diligently, despite all of these challenges and attempts to frustrate the process. 24 witnesses presented evidence. Advocate Mkhwebane herself, her own written evidence. This was considered by the committee together with the many sworn affidavits. The committee conducted a lengthy and legally sound process, which focused on fact-finding in a manner that was fair to all. The committee called witnesses and was presented with evidence in addition to the judgments, which contained serious adverse findings against Advocate Mkhwebane. Had any such predetermined outcome existed, the committee would surely not have plowed the time, financial and human resources into understanding the role of the public protector, the manner in which she investigated. We did not arrive at these findings lightly, and what the public and fellow members of the Assembly may not have seen was the hours and hours of diligent and consistent work that took place behind the scenes to try to unpack the charges. The drafters of the Constitution allocated the responsibility of making these findings in respect of the removal to a committee of the NA. We are confident that Advocate Mkhwebane was not denied the opportunity to be legally represented as she claims. To the contrary, the committee used its best endeavors to assist her to have access to a stated legal advice. This process culminated in a report which shows incontrovertible evidence that Advocate Mkhwebane has misconducted herself and is incompetent. Thus, notwithstanding the noise that has surrounded the work of this committee, the cries of unfairness of being a predetermined outcome, of this being a political campaign to protect untouchables, what rings crystal clear through all of this and what cannot be denied is that Advocate Mkhwebane, on the facts established, is not fit and proper to hold the high office of public protector. The success of our work has been made possible by honorable members of that committee who are robust and committed to duty, the evidence leaders, Parliamentary Constitutional Affairs Office, entire support staff, the media are covering our work, each of the 24 witnesses, the independent panel for their work. Most importantly, we thank the members of the South African public. The work we do in holding those that will public accountable is not always easy, but we persevered, steadfast in our commitment to you, our people. We believe that we have executed our duties to the best of our abilities. Where we have fallen short, we will learn from it. I have no doubt that this process will forever be recorded in the history books of our nation as a reminder to every person who performs a public function that you are accountable for your actions. With humility, herewith, I table this to this august House, the report of the Ad hoc Committee of Section 194, for your consideration. I thank you.
Thank you, Honorable Dyantyie, for the report. Honorable members, I now invite the Honorable Dr. A.T. Lotriet.
Speaker, in a 2016 matter, the Constitutional Court expressed itself by saying, "The Public Protector is thus one of the most invaluable constitutional gifts to our nation in the fight against corruption, unlawful enrichment, prejudice and impropriety in state affairs, and for the betterment of good governance." And I agree, Speaker. The office of the Public Protector is one of the most invaluable gifts to our nation. But provided that the incumbent to that office lives up to and complies with a set of values, principles and requirements required of a public protector. But let's look at what is expected and required of a public protector, as very well summarized by Mr. Hassan Ibrahim when he appeared before the Section 194 Committee. At the very least, the Public Protector must meet the constitutional requirement of being fit and proper as an objective requirement. The Public Protector must be beyond reproach, a person of stature and suitably qualified, acting with dedication and capable of maintaining high standards. The Public Protector should be conscientious and have the integrity required to be entrusted with the responsibilities of the office of the Public Protector and to discharge the substantial constitutional duties and obligations. Added to this, the Public Protector must exercise functions with actual and demonstrable independence, impartiality, dignity and effectiveness. What is also important, that the Public Protector must maintain credibility, scrupulous honesty and personal integrity. Openness and transparency should be part of the office and how it operates, and it should always work in good faith. But very importantly, Speaker, at all times, the Public Protector must not put personal interest over and above the public interest, and not put personal interest above those of the office of the Public Protector and the mandate of the office. This is a very high bar set, and the incumbent whose responsibility is to give effect to it. Speaker, it is this Parliament's responsibility to ensure that the Public Protector lives up to this, and that the office of the Public Protector, this invaluable gift to our nation, is protected. It is therefore a seminal point in our democracy today, where Parliament is requested to express itself on the fitness of the incumbent Public Protector to hold this esteemed office. Yes, it is a first for Parliament, but at the same time it is an indictment that it was allowed to come to this point. However, as the National Assembly, we can today give effect to what the writers of our Constitution had in mind when the office was created as a Chapter 9 institution. Speaker, it was more than a year-long process to get to the point today. It was a year where the NA had to develop new rules and directives to give effect to Section 194 of the Constitution. It was a year in which the committee and the public were exposed to every trick and tactic in the Stalingrad Handbook. A year in which court case upon court case was launched to stymie the work of the committee, and where the courts found again and again in favour of the committee and Parliament. It was a year in which committee members, the chairperson, evidence leaders, and above all the witnesses were exposed to insults, attacks, threats, and a total disregard for the dignity of Parliament and its processes by the Public Protector and her legal team. This is not what our citizens deserve. Not only were the actions and behaviour we all had to witness beyond any level of dignity and decorum, but it was a reckless abuse of taxpayers' money. Millions upon millions wasted by the Public Protector and her team on frivolous and irrelevant arguments and witnesses called, as well as the never-ending demand for postponements. In fact, Speaker, it all amounts to a staggering 160 million rand if you add all the cost orders and the legal costs, money we won't get back. Although we had the opportunity as the NA to develop new rules and directives, we have to, as a lesson learned from this episode, obtain clarity on what is reasonable legal assistance. What does it mean, and what is the extent to which taxpayers' money can be used for such purposes? It cannot be an open-ended, unlimited and unfettered right and provision. It is also to understand that the individual, the incumbents, must be separated from that of the office. And Speaker, if I have to be honest, if we look at what we experienced, the evidence that we've heard, it is clear, without a doubt, that Advocate Mkhwebane cannot proceed as the Public Protector. We can correct the situation. We can protect the office of the Public Protector. We can ensure that the citizens of South Africa are protected from an incumbent who does not comply with the high bar set for the Public Protector. And Speaker, we can again do it, not only today, but also to ensure in future that we do not find ourselves in this situation by not heeding when concerns are raised about a possible incumbent. So, Speaker, today we can change history, we can correct the wrong by supporting the removal of Advocate Mkhwebane. Thank you.
Thank you, Honourable Dr. Lovely. The next speaker is Honourable OMC Mautwe.
Thank you very much, Speaker. Speaker, myself and the President of the EFF participated in this process from its inception. The President of the EFF would have been here to participate in this debate if he was not persecuted by the alliance of the ANC and the white right-wingers who have now forced him to appear in court on frivolous charges. The report we are required to endorse today is a product of a process that has been grossly unfair to the Public Protector and which has been nothing more than a vindictive political witch hunt against the PP. As the old English saying goes, in matters of conscience, the law of majority does not work. Here today, Speaker, the uninformed majority seeks to railroad all of us to impeach a person not liked by the establishment. Here today, we see Parliament being used to break the law in order to protect the powerful. This report was hurried and ignored basic principles of fairness that are normal and ought not to be negotiated in a process such as this one. It is a clear demonstration of the determination of the chairperson to move with speed to impeach the PP regardless of the litany of procedural mishaps committed by the committee since inception. The hurried nature in which this report has been prepared lays credence to the view held by the PP that this is a frivolous political process meant to punish a person who is not compliant with the dominant narrative which seeks to uphold or hold up the current head of state as a saint. Apart from the many procedural own goals, Speaker, by the chairperson and the committee, the most important issue at the moment is that the PP has not had legal representation in the committee since the termination of the funding for legal fees by the acting PP since the end of March. The acting PP's belated offering of a 4 million rand has been mired in controversy, which has not allowed the Public Protector space to have legal representation. Firstly, the acting PP indicated that Advocate Mkhwebane must appoint her legal representatives herself and manage the additional 4 million that the office of the PP made available as she wishes. This was unheard of and placed the PP in a very precarious position because she is here to account for her performance as the PP and not as a private individual. Secondly, this committee railroaded the PP to have the state attorney as the attorney of record. This was done despite the PP having raised concerns about the conflict of interest of the state attorney. This was disregarded by the committee again, further exposing the PP to a state-sanctioned witch hunt whose figurehead has always been the chairperson. When the PP finally managed to appoint Chinese attorneys, the committee refused to give them time to acquaint themselves with the record. On what basis were the attorneys going to brief counsel if they themselves did not have an opportunity to study the record and get to know the case? Chairperson, Speaker, Rule 129 AD requires that this committee must conduct its proceedings in a reasonable and procedurally fair manner. We can never claim that the conduct of the chair was reasonable or fair in the manner he has handled this issue. From the initial directives that the chairperson issued right up to the end, this process has been grossly unfair to the PP. The findings in the report that the PP demonstrated incompetence in relation to the charges against what she faced were therefore predetermined. This is the mandate that the chairperson and the evidence leaders were given, and these findings were made without affording the PP with her constitutionally enshrined rights to legal representation. The fact that the report mentioned that the process will be moved after the term of this PP expires in October is proof enough that this process is no longer about justice, but about punishing an individual. Parliament can be reduced to a tool for punishing individual who seeks to disagree with the powerful. We therefore reject the report and we reject the political witch hunt initiated by the DA and supported by the ANC alliance to punish Advocate Mkhwebane in order to protect Mr. Ramaphosa. We reiterate our stance as the EFF that we reserve our right to take this report and the illegal adoption of this report by this Parliament on judicial review, and we invite all interested parties to join us in doing so, including Advocate Mkhwebane herself and all justice-loving individuals in this country. I thank you.
Thank you, Honorable Mautwe. The next speaker is Honorable Zet Majozi.
Thank you, Honorable Speaker. It is with a heavy heart that I quote the IFP founder, parliamentary leader and President Emeritus, His Excellency Prince Mangosuthu Buthelezi, who sadly passed on this past Saturday. His Excellency once said, and I quote, "We have within us the DNA of unity, of integrity and truth. Over 44 years of the IFP establishment and legacy, we have consistently been the champions of democratic ideals. Throughout the liberation struggle, no matter the twists and turns, Inkatha remained true to its mission." And I close quote. As we continue with the work of Parliament today, and for the years to come, may we all be guided by the unity, integrity and truth that His Excellency stood for. Honorable Speaker, the core function of the Public Protector is to investigate any conduct of government and administration that is seen as improper and prejudice, as their main objective is to defend democracy and its citizens. Ironically, the Committee on the Section 194 Enquiry had to deal with many unnecessary obstacles caused by the Advocate Mkhwebane, which made it extremely difficult for us to ensure that recommendations were reached within a suitable time frame. South Africans deserve a public protector who is both competent and impartial, and one who does not allow personal politics and dictate how the office is run. The occupant of the Public Protector's office must be unbiased, exercise its power, and perform its functions within fear, favor, and prejudice. The Public Protector must be able to investigate matters and protect the public against issues such as maladministration in connection with the affairs of government or improper conduct by the person performing a public function, which includes the President of the country. It took the committee 14 months to reach a concluding recommendation, a draft report. However, it was not a fault of the committee. Rather, it can be attributed to the relentless kick-for-touch tactics employed by the public protector. The committee was essentially held at ransom for 14 months, dictated to by legal teams that were either not present or not adequately prepared. For over a year, state resources were wasted by a person who was supposed to act as a custodian of the Chapter 9 institution. Chapter 9 institutions are the backbone of our democratic institution, as they protect citizens against decisions that are not in their best interest. Based on the evidence provided in the form of both verbal and written reports, it has given us shocking insights to see that suspended public protector Advocate Mkhwebane is guilty of misconduct for ignoring various findings and victimizing officials during her tenure. She, as the figurehead of Chapter 9 institution, should have been promoting transparency and accountability. Yet the Section 194 Enquiry Committee was forced to become a public protector and perform a very function she was mandated to. It is unfortunate that the committee had to exercise the full extent of its parliamentary power and might to engage with the public protector, as she was obstructive in promoting the principles of accountability and transparency. Our country can ill afford to have an integrity of accountability structures, as crucial as the public protector's office being called into question. If this inquiry has taught us anything, it would be that the individual taking up the role of the public protector needs to embody the equalities of supporting the best models of democracy and act as a watchdog. These are the principles our late father, founder, and leader of the IFP, His Excellency Prince Mangosuthu Buthelezi, has always called for and instilled in this parliament. May his soul rest in peace. The IFP supports the report. Thank you.
I thank you, Honorable Machosi. I now invite the Honorable Dr. C.P. Mulder.
Honourable Speaker, Honourable Deputy President, colleagues. Today is rather a sad day. It's a sad day because for the first time since 1994, we are discussing the removal of the chairperson of a Chapter 9 institution. It's a sad day. Chapter 9 is a very important part of our Constitution. It deals with state institutions supporting constitutional democracy. The PP is the first to be mentioned in that section of the Constitution. In the past 18 months, the Section 194 Committee dealt with this matter. It was the most comprehensive, most thorough, and most fair investigation process in Parliament since 1994. This is the document. This is the work, 404 pages that we dealt with. That was the document that we dealt with, the report. At the first full meeting of the committee, after having listened to the exposé of the Public Protector's legal representative, I said the following. I said in the committee that the strategy of the Public Protector was very clear. Drag this process out as long as possible, frustrate Parliament and try every trick in the book to make it impossible to make a finding. A legal representative at the time took a very strong exception to what I said. But after 18 months, we all know that I was right. The strategy was further to create the impression of a vulnerable poor victim of an evil conspiracy. Despite the legal representation, desperate for legal representation to protect her, unlike the ordinary people, the Public Protector had the benefit of legal representation of her choice and was assisted by 4 legal practitioners from the beginning of proceedings at a cost of at least 36 million rand of the people's money. No one in South Africa since 1994 was assisted in that way. In a country where the people are literally starving and where about 60% of the youth are unemployed, it was revealed in November 2022 that the so-called People's Advocate had already received 13.1 million of the people's money to represent the Public Protector. Advocate Mpofu displayed his disregard for the poor and unemployed by calling the 13.1 million rand peanuts. Peanuts. That is the attitude about the poor and the unemployed. The Constitution is very clear. The PP can only be removed on the grounds of misconduct, incapacity or incompetence. The committee found numerous examples of misconduct and incompetence. Earlier, already the Constitutional Court found in the Reserve Bank case, Advocate Mkhwebane's entire model of investigation was flawed, and this type of conduct falls far short of high standards required for the office. The Section 9 committee reached consensus that Advocate Mkhwebane has misconducted herself on multiple occasions and in the most egregious manner. Further, did she demonstrate an unacceptable and debilitating level of incompetence. And that's why the committee recommends to Parliament that she should be removed today. The EFF made a number of points today to say every time this is a vendetta against the PP because she found against the executive. It's simply not true. You see, there was a previous public protector who made very bad findings against the former executive, and that public protector was not removed. Why? Because she was not incompetent. She was not incompetent. We can do something about this today. We can do something about this today together. My appeal to each and every member is to support this motion. Let's bring dignity back to the office of the public protector. The self-protector needs to go today. Thank you very much.
I thank you, Honorable Dr. Mulder. I now invite the Honorable M.E. Soekers.
Honourable Speaker, there has been a concerted effort to discredit this process. The evidence leaders and parliamentary staff, most of whom are women, became collateral damage in an attempt to paint Advocate Mkhwebane as a victim of an abusive process and targeted conspiracy. The ACDP strongly rejects this. The ACDP entered this process with an open mind to establish the facts on the matters before the committee. This process brought into sharp focus the role of Parliament and its oversight function over Chapter 9 institutions. It is our responsibility as office bearers to maintain and uphold the principles of our constitutional democracy. It is our duty of office and our duty to the people of this nation that should be our primary concern. The cost of this inquiry is carried by the taxpayer. We cannot separate the cost from the overall aims of the inquiry or the constitutional obligation of the individual who occupies this office. For us not to mention the flagrant disregard for constitutional duty and obligation as it relates to accountability displayed by Advocate Mkhwebane would be amiss. Mr. Hassan Ibrahim, in his address to the committee, likened the public protector to a superhero. He articulated the intention of the drafters of our Constitution in an idealism that is regrettably missing in the public service today. The high ideals that would place consideration of the poor and the vulnerable above self. There is no greater form of elitism but for the poor to beg on their knees for their schools to remain open and for the public servants to have an open check to defend poor decision-making in long drawn-out battles in court on the public's dime. Such court expenses robs the poor of justice, justice which they cannot afford in a court of law. In the end, the deliberate delays, the escalation in cost because of it, and the behavior of the current public protector through her legal representatives of choice was an insult to this Parliament of the people, which she is accountable to. The process demands fairness and an open mind. The principles of fairness to the individual who is the subject of the inquiry cannot be at the expense of the people of South Africa. It is our submission that the outcome of the inquiry speaks to these principles of fairness, but with the people of South Africa in mind and the constitutional obligation put upon the public protector foremost. The political theater that grabbed the attention of the nation showed a blatant disregard for the ideals that so-called liberation heroes profess. People like Mr. van Lochenberg and Mr. Samuel were mistreated in this Parliament of the people. Their right to dignity and fairness flagrantly disregarded, as was the concerns and the rights of the people of Vrede. I thank you.
Thank you, Honorable Sukas. I now invite the Honorable General Bantu Olomisa.
Honorable Speaker and honorable members, in July 2019, Advocate Mkhwebane committed the cardinal sin of doing her job too well. She wrote a report on an investigation into allegations of a violation of the Executive Ethics Code through an improper relationship between the President and African Global Operations, formerly known as BOSASA. The ANC and DA have laid a charge against her for doing this. The evidence we have had in the Section 194 inquiry is that certain companies had donated money to the CR17 campaign. If you want to see proof of the names of the people who received payments in the CR17 saga, here it is. Read it and you will see the relationship between these companies and senior ANC leaders and key operators. The question why the President went to court to seal these records is to hide where these monies came from. These companies include, amongst others, BOSASA, Motlakeng, Maverick State, Linked Environment Services, and Behavior Change Agency, a company which featured in the linked bank statements, which later got a contract for the presidency's COVID-19 communications campaign. It wasn't the usual suspects like the big companies, but it was companies that were systematically pilfered through government departments and municipalities who funded this campaign. It is ironic that former DA leader Mkhwebane, who raised the alarm and took the matter to the public protector, found himself out in the cold. And now the DA is in cahoots with the ANC to remove Advocate Mkhwebane. Is this why my money was sacrificed? It seems Advocate Mkhwebane had hit a raw nerve with her 2019 report, and that the ANC has closed ranks and with a vengeance, and we are at the juncture where they are merely getting rid of her for doing her job too well. Finally, the House should come up with a mechanism to establish which companies are doing business with government and had donated to this campaign, and why monies had ended up in some cabinet members' pockets, as shown in this document. The UDM, therefore, categorically disagree with any course of action that sees Advocate Mkhwebane's departure from office. So mkwati ke sithi into yakuthi njengubuphethe ukhokhele jonga le mali yaqokelwa kwi-State Department sithi kwezinye ministers zakho niyeke lo muntu obesenza umsebenzi wakhe amasela la.
Deputy Chief Whip of the Majority Party.
Thank you, Honorable Speaker, Deputy Speaker, His Excellency the Deputy President, members of the Executive, our colleagues, members of Parliament, our guests in the gallery. Honorable Speaker, when the office of an Ombud or Public Protector in the new constitutional dispensation was first proposed in this country, the ANC, in its policy document entitled Ready to Govern, Policy Guidelines on a Democratic South Africa said, and I quote, the ANC proposes that a full-time independent office of the Ombud should be created with wide powers to investigate complaints against members of the public service and other holders of public office, and to investigate allegations of corruption, abuse of their powers, rudeness, and maladministration. The Ombud shall have the power to provide adequate remedies. He or she shall be appointed by and answerable to Parliament. Honorable Speaker, our former President Nelson Mandela explained the thinking behind the creation of the Public Protector to the African Regional Workshop of the International Ombudsman Institution in 1996 as follows. We were mindful from the very start of the importance of accountability to democracy. Our experience had made us acutely aware of the possible dangers of a government that is neither transparent nor accountable. To this end, our Constitution contains several mechanisms to ensure that government will not be part of a problem, but part of a solution. Close quote. The importance of the Office of the Public Protector cannot be stressed enough. When we adopted our final Constitution, we understood that it was a strategically important step to move towards the kind of South Africa we all knew we wanted. In 2016, the Constitutional Court described the Public Protector as one of the most invaluable constitutional gifts to our nation in the fight against corruption, unlawful enrichment, prejudice or impropriety in the state affairs, and for the betterment of good governance. Embarking on the Section 194 process, which we undertook, was important for the preservation of this important state institution which supports our constitutional democracy. Honorable Speaker, the independent panel's function was to conduct and finalize a preliminary assessment of the motion to determine whether there was prima facie evidence showing that Advocate Mkhwebane had indeed committed misconduct and or was incompetent as alleged. The independent panel made its own findings and submitted its report. Not all the charges were sustained. The independent panel indeed found prima facie evidence of the misconduct and incompetence and recommended that the National Assembly should establish the committee. Our task as the committee was to establish the veracity of the specific charges of misconduct and incompetence laid against the Public Protector. We bore the duty to interrogate the evidence and apply our minds in line with our constitutional duty of oversight, and not to merely rubber stamp the report. The committee was not a court of law, but a body comprising of elected representatives who had to discharge a function uniquely and constitutionally allocated to a committee of the National Assembly. From the inception, the position of the ANC was to consider the facts and evidence placed before the committee and apply its mind. We approached the work with an open and inquiring mind. We had no predetermined outcomes. We heeded the caution made by the chairperson that we should stay focused at all times, pursue the facts and evidence, adhere to the procedural fairness, uphold the rule of natural justice, audi alteram partem, and stand on rationality. This would help members avoid being trapped in the two extremes that were out there. The one extreme being that the Public Protector was not fit to hold office, and the other extreme being that the public protector was fit to hold office, and therefore there was no need for this inquiry. The ANC was consistently present in every meeting. We engaged with the evidence, posed questions to the witnesses, and most importantly, engaged the public protector's sworn statements and posed written questions to her. Fairness was demonstrated at all material times. Advocate Mkhwebane was given the opportunity to present her sworn statement and cross-examined all witnesses. The revised procedure allowed her an election to answer questions from members and evidence leaders in writing or orally. She was also provided an opportunity to make an oral or written closing argument. We are satisfied that a legal process was followed. Honorable Speaker, we experienced many challenges. Understandably, this was a novel process after all. Many things could have derailed our work, but we kept our focus. We understood that Section 237 of the Constitution charges us to perform our constitutional obligations without delay. In respect of the allegation proffered against the advocate Mkhwebane, and having considered the evidence, we share the committee's view that advocate Mkhwebane misconducted herself and displayed incompetence. Advocate Mkhwebane has also repeatedly neglected her duties and that of a constitutional office bearer, an officer of the court, and an organ of state bears. The inadequacies in the Friede investigations and the excesses of the lifeboat investigation, both of which caused serious harm, are such that they would have destroyed a reasonable member of the public's confidence in her ability to discharge her duties and functions. Honorable Speaker, Ms. Caroline Zulu Sokoni gave evidence based on her role as the public protector of the Republic of Zambia and said, the Ombudsman is the only institution which the poor can call upon. We should not allow those poor people to lose heart and lose faith in the institution that has been set up for them. Ngalogo somlomo lohloniphekile sithi nangabe kuneliphenyo lelikhona lelendekako kufanele ukuthi nalabo labathinzekako bonke especially labo lekufanele bahlomule kulowo mklamo kufanele babe sebayabudwa nabo ukuthi kwendekani kuloko. Kepha kuleli phenyo leli lelendekile laseFriede amange bantu babudwe labo labathinzekako labo labahluphekile labo hulumende labalungisele ukuthi kufanele bahlomule kulomklamo bashiywa ngaphandle bangabudwa. So ngaloko sivumelana naye Ms Zulu Sokoni kulesiphetho sakhe lasishito ukuthi vele kufanele leli office libe office lebantu labahluphekile. Ngiyabonga.
I thank you, Honorable Deputy Chief Whip. Our next speaker is the Honorable V. Zungula.
Enkosi Speaker, kuzungula. Enkosi. This action to seek to remove a sitting head of a Chapter 9 institution will do more harm than good for the country. Effectively, the DA-led ruling party is sending a strong message that if you are in public service and you don't toe the line of the ruling party, the party will embarrass and chase you out of office. Never has it happened anywhere in the world where a sitting ombudsman is removed, especially after finding against the powerful presidents and ministers. Who's next in this hateful brutality? Is it going to be IEC commissioners, judges in the Electoral Court? Basically, everyone who dares to uphold the law and constitution will be met with the wrath of the DA-led ruling party. This action is clearly set out to make independent Chapter 9 institutions to work in fear. It's either you rule in favor of the most powerful sections of society or you'll be punished. Yes, all people must account. Hence, we say the removal of a public protector should be based on strong and justifiable grounds to prevent any erosion of this vital office. The process to determine the fitness of the public protector was filled with bias against Advocate Mkhwebane. It is a fact that Advocate Mkhwebane from the onset had to fight up until the level of the Constitutional Court for legal representation in the inquiry. The bribery allegations against 3 members of the ANC is still under investigation by the SAPS. How can Parliament proceed with impeachment, yet these damning allegations that erode the credibility of the process are still under investigation? The committee, once more, was in contempt of court when it proceeded to work, while Advocate Mkhwebane was not legally represented by lawyers of a choice. The process was unjustifiably rushed. The changing method for Advocate Mkhwebane from oral to written testimony is an example of how eager the ruling party wanted to finish this before her term ends so that it gets to this point of removing her. It is also common cause that the change from oral to written testimony is something that was prophesied by the late Honorable Jomat Peterson, which means indeed there was a predetermined outcome. A process to remove a public protector must be free from bias and actions that erode the credibility of the process. With that being said, we as the ATM are not going to support a hateful resolution that is akin to the apartheid parliament creating a law to keep Robert Sobukwe in prison indefinitely. To Advocate Mkhwebane, uZimo akukhusele le nkohlakala yenziwa yi-DA ekhokhela i-ANC ayizuphumelela.
I thank you, Honorable Zungula. The next speaker on our list is Honorable B.N. Heron.
Thank you, Madam Speaker. Madam Speaker, the sorry saga of Advocate Mkhwebane's tempestuous occupancy and now forced removal from the Office of Public Protector reflects the steady politicisation of the office that was not the intent of the drafters of Chapter 9 of the Constitution. Mkhwebane's legal strategy not to respond to evidence placed before her at the Section 194 inquiry denied the country the opportunity to hear her perspectives. Her withdrawal from participating in the proceedings also denied the committee the opportunity to consider her evidence. Had she participated and given the evidence, she may have been able to persuade at least some of us that not all the charges were sustained. She was the first public protector who, after the courts ruled that the office findings were binding, had decisions commonly taken on review. By remaining quiet, she left members of the committee no legal grounds not to recommend her impeachment. The process therefore passed technical muster. But the manner in which the office has become a critical expression of factional politics and opposition party opportunism damages its integrity and purpose. This challenge predates Mkhwebane's appointment. The objective of Chapter 9 institutions is to strengthen constitutional democracy, not to work as politicised levers. The Constitution affords parliamentarians a key role. The institutions must be independent and impartial, may not be interfered with by any person or organ of state, and are accountable to the National Assembly. Chapter 9 lists 5 functions for the public protector, the first of which is to investigate any conduct in state affairs or in public administration in any sphere of government that is alleged or suspected to be improper or to result in any impropriety or prejudice. Another function critical to the right of the people to hold the state to account states that the office must be accessible to all persons and communities. But what has happened over the past decade or so is that politicians have increasingly used the office as a political football to pursue political goals, including litigating against perceived enemies without having to incur legal fees. The Executive Ethics Act demands that the public protector investigate any alleged breach of the Act and Code. The only hedge that we have to insulate this requirement from subjective political abuse is the integrity of the office bearer. Mkhwebane's removal will be a victory for some politicians, though not necessarily for the integrity of the systems. What we should be asking ourselves is what this process has taught us about the appointment of public protectors and how to prevent the office being subsumed by political interest. We feel procedurally and morally obliged to vote for the impeachment of Advocate Mkhwebane, though we do not celebrate doing so. Thank you.
Thank you, Honourable Member. I now invite the Honourable Sheikh Imam.
Thank you, Honourable Speaker. Let me start off by saying that in terms of the recommendations that was put forward in respect of the removal of Advocate Mkhwebane from the Office of the Public Protector, the committee deliberated on this matter. Millions of rands have been spent, waste of taxpayers' money. If you see what the current Minister of Finance says, the financial situation we find ourselves in this country, but just look at the amount of money that has been wasted on this matter. Now, very importantly, Honourable Speaker, I find a level of hypocrisy in this House, and let me tell you why I say that. The Constitutional Court upheld a Pretoria High Court ruling that found that Mkhwebane was dishonest in her investigation. Who appointed those judges? This House. The Public Protector lost an application for leave to appeal an order by the High Court in February 2018. Who appointed those judges? This House. A full bench of the High Court set aside a controversial report and its remedial action, which ordered the SIU to recover more than 1 billion rand from APSA. Who appointed those judges? This very House.
Honourable Sheikh Imam, I'm really sorry. Please take a seat.
Take a seat.
What is your point of order, Honourable Member?
The point of order is that Parliament does not appoint judges. The Speaker on the podium is misleading the House. I'm calling a point of order on that one. He must stick to his speech. He must not mislead this House.
Thank you very much. Honourable Kalipi, take your seat. You may proceed, Honourable Member.
Thank you very much. Recommendations do come to this House, does come through to the committees, okay? But no one in this particular House has ever rejected. Nobody in this House have ever rejected or raised concerns about any of the judges, even when they were appointed by the judge president in this country.
Honourable Sheikh Imam, I'm really sorry. Take your seat. Honourable Shivambo.
Not when a member stands up here and says that we are responsible for the appointment of judges, it's misleading the House and it's misleading all of us. And it's purposeful. We understand the limitations of the NFP and that they're not coming back next year, but don't mislead us. We are not responsible for appointment of judges. It's done elsewhere. It's not us. And to repeat that as if it's a factual basis, it's misleading, and we must not allow that to just pass. It's not a point of debate. It's a factual issue. We are not responsible as members of Parliament for the appointment of judges. And the member must withdraw that particular nonsensical insinuation. It's as simple as that.
You've made your point. Order. Honourable Shivambo, you are partly correct. But if I may also correct you, members of Parliament, Parliament is represented. It just holds. Parliament is part of the processes of appointing judges. So can we leave it at that? There's no need for us to debate on the matter. Thank you very much, honourable members. Proceed, honourable member.
I think Honourable Shivambu should attend to the crisis in his political party, firing 200 some odd members, asking his members to be corrupt in going to fine 1.5 million rand for transport. Let me also say to all these other EFF members, don't you worry, you'll be next, and you'll be next, and you'll be next, and you'll be next. All of you soon. Now, Honorable Shivambu is very selective in his hearing, because he did not hear what I said in the end, that I also said that nobody in this house ever rejected any judge or anyone or commented or raised concerns about anyone that were appointed. And we talk about the separation of powers. The judiciary has a responsibility to deal with these matters. Now, judge after judge after judge has found the public protector wanting and failing to carry out their responsibility.
Honorable members, order. Honorable Sheikh Imam, fortunately your time is up. Thank you.
The NFP will support the report tabled here today. Thank you very much.
Thank you very much, Honorable Member. I now invite the Honorable Tape.
Musa Khotla, Deputy President, members of Executive, honorable members. Honorable Speaker, we must acknowledge that this committee drew so much attention locally and internationally. As a pioneer, a multi-party committee, obviously with different views, coupled with many theories around its mandate. Let me also attest that this was a committee of parliament. And interestingly, as members, we agreed on the basic principles or guidelines that would have navigated us through uncharted waters. According to Katifi report from the Institute of Principal Studies, principles set the foundation. They recognize what is true in new or unknown situations. So principles, in a way, helped us as a committee to interpret and apply the truth to the evidence we received, hence the outcome today. So as the committee, we became principled and chose gore, ga re kitla re seka motho, re a go seka molato. Ra ba ra tsaya kgakollo go tswa mo go Davis Thorio, ga na re go botlhokwa gore o lebileng. Se se botlhokwa ke se o se bonang. It's not what you look at that matters, it is what you see. So some of the wrongs we saw when we looked at the PPSA and the evidence that was put before us are the following. Weaponized and misuse of disciplinary policy to instill fear, intimidate and victimize some employees, whereas the policy requires that disciplinary measures be fair, not punitive, and be used as a corrective measure. Coercion of employees to set unreasonable and unrealistic deadlines for reports without considering human and financial challenges of the office and the complexity of matters. This resulted in employees rushing to complete investigations to maliciously comply because they feared audit letters and subsequent disciplinary actions that often followed. Executive managers who served the office under a number of public protectors demonstrated how this destroyed the internal capacity of the office and how it led to low staff morale and unhealthy work environment characterized by fear. We heard how the PP sought to eliminate anyone who dared to differ with her. Diversion of financial resources meant for outreach programs to improve accessibility of PPSA and enable investigators to do physical inspections. Investigators were left only with being able to conduct desktop investigations, thereby impacting on effectiveness and litigations due to poorly conducted cases. This resulted, honorable members, also in a high turnover of skilled and competent investigators and a weak institution that could not deliver quality work as expected. There was bypass of quality assurance mechanisms during the investigations of some of the charges that were served before us, such as CR17 and the SARS unit matters, with investigation being kept closely to the PP and certain individuals, deliberately ignoring certain evidence presented to her without explanations, as well as deliberate misuse or misleading of the wrong executive ethics code. And still, as the committee, we remain principled that we will not judge the person, but will look at the wrongs that were done. Demonstrable limitations on understanding the powers she possesses, lack of knowledge on some aspects and application of the law, and making far-reaching findings like that of the total implementation of the Inspector General of Intelligence report when she was advised that the SSA could not authenticate the report, nor did the IGI have jurisdiction or to investigate SARS in terms of the National Intelligence Act. These, honorable members, are few examples of many instances of incompetence and misconduct that characterize the tenure of Advocate Mkhwebane. As the committee, we cannot turn a blind eye to the devastating impact this has had on the office and the public perception about the institution that is meant to strengthen our constitutional democracy, lest we fail on our mandate, that of probing her fitness to hold office. Kajalo Musa Khotla re le mokgatlo wa African National Congress, re dumelana le tshwetso ya gore mosireletsi wa setšhaba a tlosiwe mo maemong a gagwe jaaka fa bopaki jotlhe jo re bo reboletsweng ra bo ra bo sekaseka bo supile fa sa itekanela go tswelela ka tiro e lebaka legolo ke gore ga ra seka motho re sekile molato ke a leboga.
Thank you, Honorable Sape. I now invite the Honorable Member S.M. Jafta.
Thank you, Honorable Speaker. We must place it on record that our position on this report must not be confused. We hold a strong view that the flag bearers of our Chapter 9 institutions are not beyond reproach. We have full confidence in the judiciary, particularly the Constitutional Court and all other courts, including KZN High Court Division. We believe that the office of the Speaker has been impartial in its dealing with Section 194 committee. We place all this on record to underscore the following. While we agreed that this process was above board and that the courts and the office of the Speaker have been fair throughout the process, we believe that this report must be viewed by members from an Ubuntu standpoint. We do not carry any brief for Advocate Mkhwebane. Her term will expire in October. Impeaching her just a month before it expires would be in line with the principle of Ubuntu, which has since been accepted as one of the values of the Constitution. The Constitutional Court's judgment in Magwenyana, for example, reminded us of the basic underpinning of Ubuntu as entailing a balancing of the interests of society against those of the individual, for the maintenance of law and order, but not for dehumanizing and degrading the individual. The Constitutional Court went on to rule that Ubuntu translates as humanness. It expresses itself in umtu ngumtu ngabantu. In Furman versus Georgia, the Supreme Court of Appeal of that country pronounced that the measure of the country's greatness is its ability to retain compassion in time of crisis. The Holy Quran tells us that Ubuntu or Azabia embodies compassion and unity. Honorable Speaker, Steve Biko affinities to Ubuntu was premised on the recognition that we needed to place less emphasis on power and more on humanity. Rev. Martin Luther King reminded us in 1965 that all humanity is tied together. The Holy Bible speaks about holiness and forgiveness. The late Archbishop Tutu told us that in Africa we have something called Ubuntu in Nguni languages or Butu in Sotho, which is difficult to translate into English. It speaks about holiness, it speaks about compassion. The AIC will accordingly not vote in favor of this report. Thank you.
Honorable T. Luate, this is his maiden speech, honorable members.
Honorable Speaker, on the 14th October 2016, the term of office for Advocate Thuli Madonsela as Public Protector came to a glorious full-time conclusion. With the present Public Protector, court judgment after court judgment have been scathing of her failure to understand the law and her role as the public protector. She dabbed in politics. This was utterly wrong. Advocate Thuli exemplified how a public protector should go about her work. No public protector should ever do that. Advocate Mkhwebane allegedly collaborated in secret with the former State Security Agency former Director General Arthur Fraser, and also with former President Jacob Zuma during the CICX report investigation. This made her position as public protector totally untenable. A new public protector must sever all ties with political parties, particularly the governing party, and become a committed servant of the law, the Constitution, and the people. A new public protector must do what Thomas Becker, a great friend of King Henry VIII, did when he was appointed Archbishop of Canterbury. He gave up being Lord Chancellor and placed the interest of our church, of the church, up front and center. Politics took a backseat. Misdemeanors by the powerful must be confronted head-on, constitutionally, and in the true interest of our people and the country. Hard lessons have been learned. Today we are called upon to consider impeachment of the Public Protector Advocate Busisiwe Mkhwebane, as recommended by the Section 194 Committee. This call is an enormous conscience call to all of us in this House. It impacts on understanding the oath that we all took. While the Section 194 Committee report tells us of what transpired, we owe it to the country and the Constitution that it be the last time we have to find ourselves in this situation. And I thank you.
I thank you, Honorable Luate. Thank you. I now invite the Honorable M. Nyotso.
Madam Speaker, the position of the Pan-Africanist Congress of Azania on the recommendations for removal of Advocate Mkhwebane from the public office is crystal clear. We do not support the recommendation. We definitely voting against it. The ruling party is exposing itself for everyone to see their ugly hatred of women. They punish one of their own severely in order to introduce another timid and useless one of their own, whom they can use like a puppet. Advocate Mkhwebane is used as a pawn in an internal power struggle of the ANC. She is a strong African woman who is not ready to go down without a fight. He has made the ruling party to rig the rules in a sham inquiry and impose their factional tendencies to punish a woman who truly intended to make the Public Protector's Office an institution that works for public at grassroots level. The masses of the people continue to have many confrontations with the government that has no conscience and no real interest in the affairs of their constituencies. In our view, the ruling party is no longer with the letter and spirit of the Constitution. They have taken an oath to serve and protect. The internal conflict with the ruling party is overlapping
into the state machinery and into usurping powers of Chapter 9 institutions, such as the Public Protector, to impose a sinister agenda-based psychological attack on a woman they cannot control. The removal of Public Protector is based on the maneuvers to gaslight an independent woman of substance. This is lack of respect for African womanhood. The PAC of Azania will oppose the ANC of South Africa and DA for removing Advocate Mkhwebane.
Thank you, Honorable Nyotso. I now invite the Honorable Member MGE Hendricks.
Thank you very much, Honorable Speaker. Honorable Speaker, I would like to take this opportunity to thank the chairman of the committee for his fairness and his leadership, and the members of the committee for the decorum where everyone was treated equally. Honorable Chair, this was a learning experience. It was the first time for many of us and many experienced honorable members. And it is my view that in terms of the Superior Courts Act, the Office of the Public Protector should in fact be a specialist court because of the high standards that is expected of a public protector. Honorable Speaker, this was an expensive DA motion, 160 million. I think that's why 60 of the ANC members abstained from that motion. Al-Jamaa accepts the report, but not the harsh sanction. We call for a lesser penalty, but political parties voted according to party lines. I want to thank the Public Protector for her hard work. She got 3 consecutive clean audits, which previous Public Protectors did not achieve. She cracked the whip when she came because many in the office were lazy bums and drag cases. However, the buck stops with the Public Protector, so I suppose she must fall on her sword. Even if 90% of the cases that was dealt with was dealt by other members in the department. To take away her pension and benefit is too harsh. The offence she was found guilty was a concern, but not impeachable. The ANC must be more careful in the future to support motions of the DA. Thank you very much.
Thank you, Honorable Hendricks. I now invite the Honorable Dr. M.M. Gondwe.
Madam Speaker, no one can deny that today's sitting is the first of its kind. In fact, this sitting is seminal and foundational in its nature. This House has never in the history of our democracy had to convene and decide on the removal of a head of a Chapter 9 institution. But here we are today. We are about to vote as this August House on whether or not to remove Advocate Mkhwebane from the Office of the Public Protector. Madam Speaker, based on the evidence that was laid and adduced in the course of the inquiry, you, Madam Speaker, and I and others in this hall have little or no choice but to ensure that before the end of today's sitting, Advocate Mkhwebane is no longer Public Protector of the country. Madam Speaker, Advocate Mkhwebane has gone completely and utterly rogue. She is no longer serving the interests of the country, its people, and the office that she currently occupies. In the 7 years that she has been at the helm of this office, she's done nothing but to denigrate and degrade its standing and stature with her egregious behavior. Madam Speaker, she treats this office like her own personal fiefdom, in which she wields and exercises unchecked and unfettered power, and also makes and breaks the rules as she goes along. Madam Speaker, that is why the DA is in no uncertain terms today supporting the report under consideration by the House, in particular, the recommendation that she be removed from public office immediately. Madam Speaker, it was this House that appointed her. And it is this House that must remove her because there are convincing and compelling grounds to do so. Madam Speaker, from the outset of the inquiry, the committee embarked on what was essentially a fact-finding exercise aimed at determining the veracity of the charges of misconduct and/or incompetence contained in the substantive motion. With respect to charge 1, Madam Speaker, the committee established that Advocate Mkhwebane solicited undisclosed advice and inputs from the SSA in relation to the infamous constitutional amendment in the Reserve Bank Lifeboat Report, which constitutional amendment, Madam Speaker, sought to significantly amend or alter the mandate of the Reserve Bank of South Africa. Madam Speaker, the committee further established that the undisclosed advice and inputs that she solicited from the SSA, in particular from one Dr. Moodley of the SSA, was so significant that the wording that he proposed for the constitutional amendment was used verbatim, word for word, in the Reserve Bank Lifeboat Report. Madam Speaker, the committee further established that the consequences of the Reserve Bank Lifeboat Report were so serious and far-reaching that they severely damaged our economy. On charge 2, Madam Speaker, the committee established that Advocate Mkhwebane unjustifiably narrowed the investigation into the Freddie Dairy matter to exclude relevant and material evidence arising from the Gupta leaks emails. In addition, Madam Speaker, issues relating to the value for money received in respect of the public expenditure for the Freddie Dairy project was simply not considered. Madam Speaker, Advocate Mkhwebane also failed to report on and consider how the funds from the Freddie Dairy project flowed straight into the Gupta-owned Estina Dairy and were ultimately used. Charge 3 in the motion, Madam Speaker, relates to the incompetence of Advocate Mkhwebane. The committee established in relation to the Reserve Bank lifeboat matter that she grossly exceeded and overreached the bounds of her powers and authority when she imposed the remedial action that she did in that report, and further failed to ensure that it was appropriate and bore a rational relationship or connection to the concerns raised in the report. Madam Speaker, even though the committee did not establish a finding of misconduct in relation to paragraph 10 of charge 4 in the motion, it did, however, establish that Advocate Mkhwebane committed misconduct in relation to paragraph 11 of the same charge, specifically in that she utilized the resources of the Office of the Public Protector to obtain legal advice and initiate litigation for personal gain. Furthermore, the committee established that she failed to prevent fruitless and wasteful expenditure with respect to the legal costs of her office by litigating recklessly in several matters, including in the Gordon Pillay matter and the CR17 matter. The evidence before the committee, Madam Speaker, also showed that her engagement of external consultants of the likes of Mr. Paul Mkhwebane to render legal services with respect to litigation in which senior and junior counsel were already engaged amounted to misconduct and resulted in unnecessary and wasteful expenditure being incurred by her office, and further drove a partisan narrative against the affected parties in the judiciary. Madam Speaker, Advocate Mkhwebane has shown herself to be exceedingly incompetent and ignorant of the law and has grossly misconducted herself as public protector. She does not deserve to hold the office that she currently occupies and has never deserved to hold this office. And the evidence laid and adduced before the committee has more than confirmed this. Madam Speaker, Section 194 of the Constitution provides that the public protector may only be removed from office on grounds of misconduct, incapacity, or incompetence. This same section further requires a finding to that effect by a committee of this House and the adoption by this House of a resolution calling for that person's removal from office. As such, all that remains is for this august House to adopt this report of the committee, recommending that Advocate Mkhwebane be removed as public protector. I am therefore calling on each and every member of Parliament sitting in this hall to vote in support of this report and remove Advocate Mkhwebane immediately from office.
Dr. Condolences.
Madam Speaker,
Thank you.
The whole country and indeed the whole world is watching us right now. Let us do what is right by our hard-earned democracy and the people depending on institutions such as the Office of the Public Protector to keep government in check.
Honourable Dr. Condolences, your time is up. Thank you. Thank you. I now invite the Honorable X Ngola.
Thank you very much, Somlomo. Honorable Speaker, the speakers that came before me of the EFF, HM and UDM today presented us with a number of fallacies. They've firstly used emotional fallacies characterized by confusion, emotion, with reason and fact. They seek to use the oppression of black women to persuade society not to focus on the facts of what the committee was set up for, but want us to focus on their political sentiments and hearsay that are devoid of truth and facts. Secondly, they presented us with the straw man argument suggesting that the removal process seeks to weaken the office through the process we undertook as Parliament. In other words, they want to suggest that the non-removal of Advocate Mkhwebane from office will have the opposite effect. These arguments are not supported by fact, but by efforts of politicizing this process for political point scoring. Unlike them, we were at all times during the inquiry guided by facts and evidence. Evidence that Advocate Mkhwebane failed to dispute and provide us with justifications for her conduct. Honorable Speaker, let me remind the EFF what its leader said in 2016. When reservations were raised about Advocate Mkhwebane as a candidate for the position of the Public Protector, South Africa, in Parliament, Mr. Malema said, the institution of Public Protector is well established with rules, established practices, and independent investigators. If Advocate Mkhwebane tried any shenanigans, the institution itself would expose her for who she was. I have good news for the EFF. The institution did expose Advocate Mkhwebane, and the facts were laid bare for all to see. However, typical of the EFF, they are not friends of the truth, and that does not suit their narrative and their agenda. We're dealing with people who lack principle and change their stand at any moment of convenience without any substantive basis. We expected too much from them to participate in the inquiry by honestly and objectively assessing the evidence before them. The emotional fallacies and distractions failed in the face of the truth. Speaker, Section 195 of the Constitution requires that the holder of a public office maintain high standards of professional ethics, must ensure the efficient, economic, and effective use of resources, and must provide services impartially, fairly, equitable, and without bias. We can say without fear of contradiction that Advocate Mkhwebane fell short of all these qualities. First, her conduct before the inquiry was inappropriate and in other instances undermining the functions of Parliament. She employed every trick in the book to delay the work of the inquiry. We saw these true frivolous applications for recusal. First for the chairperson, then the evidence leaders, followed by court application to review the decision of the chairperson, not to recuse himself. And in between, bringing an application that sought to put the inquiry in abeyance until outcome of a review application, which the Western Cape High Court dismissed as baseless. We also witnessed the choreographed workout of her legal representatives. All these were aimed at delaying the work of the inquiry as she unashamedly evaded accountability. This came at a greater cost to the taxpayer, increasing the legal fees from the estimated 4 million to over 30 million. All these monies were spent on her legal fees, yet we are told that the committee denied her legal representation. Advocate Mkhwebane was entrusted with the powers of ensuring that the state resources are used efficiently on behalf of and for the benefit of the people of South Africa. She disregarded all this and chose to become the main culprit in wasting the resources of the state. These are the actions of someone who is expected to be the protector of the people of South Africa and the embodiment of accountability. This process has demonstrated how she lacked upholding principles that guide a fit and a proper individual. The committee, in line with the constitutionally enshrined principles of fairness, and extended the right to be heard to Advocate Mkhwebane. Instead of accounting and answering to the allegations leveled against her, she used the opportunity to politicize the entire process, claiming there was a witch hunt against her without any substantial basis. The facts are that the process of the inquiry was initiated as a result of court judgments that made primary findings on her competence and her lack of basic knowledge of the law and its application. Advocate Mkhwebane, the EFF, the UDM, and the ATM sought to confuse the process of the inquiry and society that there was a predetermined outcome without any substantiation. Having seen how the facts unfolded during the inquiry, we understand why Advocate Mkhwebane held this view. She was well aware of how she abused her powers in the office and how she acted with impunity and had no reasonable explanation for her conduct. As a result, she sought sympathy from the public and presented herself as a victim. She sought to confuse emotion with reason, to distract attention from the facts. The allegation that the committee had a predetermined outcome had no basis. In fact, had this been the case, we would not have interrogated and assessed the evidence of all the witnesses that came before the committee, nor would we have exonerated Advocate Mkhwebane on some of the charges like the James and the SARS subpoena matters, where the committee found there was no sufficient evidence to conclude on incompetence and misconduct. Somlomo, what was most concerning for the committee was the role of the state security agents, which influenced the remedial action in the CIX report. The extent to which Advocate Mkhwebane sought to direct Parliament to amend Section 224 of the Constitution and further prescribe how the wording of the amendment should read. The evidence before the committee revealed that the remedial action came directly from the state security agents. This conduct had the effect of undermining the independence and the impartiality of the office. Instead of reflecting on her conduct as advised by some court judgments, by doing some introspection and improving her methods of investigation, she proceeded to employ consultants and pay them with financial resources of the Public Protector South Africa to write articles and launch scathing social media attacks on the judiciary and those who were subjects of her investigations. This, Honorable Speaker, is just the tip of an iceberg of the wrongful conduct that characterized the tenure of Advocate Busisiwe Mkhwebane. As the ANC, we believe the misconduct committed and incompetence shown by Advocate Busisiwe Mkhwebane is of a serious nature and includes such acts as unconstitutionally encroaching on the jurisdiction of Parliament, the National Prosecuting Authority, and the South African Police Services, repeated material errors of various laws and legal instruments, including PRECA, the Executive Ethics Code, and even the Public Protector's own powers, the repeated failure to give out to affected parties, the selective reliance on evidence to achieve a particular outcome and disregarding relevant evidence and to assess evidence to ensure reports reflect why certain evidence is rejected, the patently incorrect manner of substantiating complaints based on inferential reasoning, not supported by evidence, and taking wholly inadequate steps when investigating. If anyone should be accused of having a predetermined outcome, is the EFF, is the UDM, is the ATM, and now joined by the PAC. They were simply not interested in the facts and the historic Section 194 process. There is no substance to any of the charges that served before the committee that they can factually and substantially disagree or claim any unfairness. As the ANC, we reiterate our position that we went on a fact-finding mission. We sought the truth from the facts. We uncovered it. We are convinced that Advocate Busisiwe Mkhwebane is not fit and proper to be public protector of a critical institution supporting our democracy. Somlomo, this parliament you are leading had to firmly and decisively protect the citizens of South Africa against a public protector that has since gone rogue. Thank you very much, Somlomo.
I thank you, Honorable Ola. Thank you. Order, honorable members. That concludes the debate. I now put the question The question before the House is that Advocate Mkhwebane be removed from the office of the Public Protector as recommended by the Committee for Section 194 Inquiry. Are there any objections? I now put the question. Those in favor of the removal of Advocate Mkhwebane from the office of the Public Protector in terms of Section 194(1)(c) of the Constitution will say aye. And those against the removal of Advocate Mkhwebane from the office of the Public Protector in terms of Section 194(1)(c) of the Constitution will say no. I think the yeas have it. Honorable Shivambu. Do you have any objection?
Thanks, Speaker. We call for division. We have to, because the Constitution says that it will require 2/3 of reasonable members of Parliament, and we think that we can be able to determine adequately that we cannot remove a public protector. So we're calling for a division.
Okay, thank you very much, Honorable Shivambu. Honorable members, a division having been called, the bells will be rung for 10 minutes. Honorable members, order. The rules of the National Assembly. I'm informed that this will be announced when you are back. We will now call the staff to ring the bell. Thank you. 10 minutes, honorable members.
T, 1, T. T, 1, T.
Order, honorable members. Honorable members, order. You may now shut the doors and take your seats, honorable members. Honorable members, okay, honorable members, honorable members, the rules of the National Assembly provide for different procedures for members to cast their votes. These include voting by electronic means or a manual voting procedure by way of a whip or by voice. The rules also stipulate that the Speaker must predetermine the voting procedure. For this division, I've determined that a manual voting system will be used, whereby each member will be called upon and requested to voice his or her vote. In terms of the rules, all members present when the question is put with the doors barred must vote or record an abstention. This rule does not apply to a minister or deputy minister who is not a member of the House. Political parties provided a list of members who will be called first when it is their party's turn to vote. After that, party's list has been called. The remaining members of the party will be called alphabetically. The Secretary will call each member from the membership list, starting with those from the majority party. Members will be called by their surname, followed by their initials. In order to facilitate this process, I appeal to honorable members to indicate their vote only, without a preamble or statement and without delay. Members must simply indicate yes or no, or abstain. This will assist the tellers in ensuring your vote is correctly captured. In the event, order. In the event, no, because you won't hear what I'm saying. In the event a member's name is called and they are present, but for whatever reason do not indicate their vote, an opportunity will be provided for such members to raise their hands after the last member is called from the list, at which point they will be recognized to cast their vote. Order. The question before the House is Advocate Mkhwebane be removed from the office of the Public Protector in terms of Section 194 of the Constitution. Those in favor of the removal of Advocate B. Mkhwebane from the office of the Public Protector in terms of Section 194 of the Constitution will vote yes. Those against the removal of Advocate B. Mkhwebane from the office of the Public Protector will vote no. Those who want to abstain will record their vote as such. Voting will now commence. The doors of the chamber will remain locked until voting is concluded. The Secretary will now proceed to call members.
Majodina PCP. Mashatile.
I vote yes.
Mashatile SP.
I vote yes.
Tsenodi SL.
Yes.
Frolic CT.
I vote yes.
Boroto MG.
I vote yes.
Ndombela MLD.
I vote yes.
Dlakude DE.
I vote yes.
Tseke GK.
I vote yes.
Khadebe BA.
I vote yes.
Cele BH.
I vote yes.
Chikunga LS.
I vote yes.
Greasy BD.
Yes.
Didiza AT.
Yes.
Dlamini Zuma NC. Absent? Absent, all right.
Absent.
Godongwana E.
I vote yes.
Godan PJ.
Absolutely yes.
Gungubele M.
Ewe.
Kivit N.
Yes.
Kodwa NG.
Yes.
Kubai MT.
Yes.
Lamula RO.
Yes.
Mandashe SG.
Yes.
Mkhunu ES.
Yes.
Modise TR.
Yes.
Motsecha MA.
Yes.
Motswaledi PA.
Yes.
Ndabeni Abrams ST.
Yes.
Chaveni KPS.
I vote yes.
Nxesi TWT.
Yes.
Nzimande BE.
Yebo.
Pando GNM.
Kiadumela.
Got it? Patel E.
Yes.
Pasha MJ.
Yes.
Ramahupa ML.
Yes.
Zikalala S.
Yes.
Zulu LG.
Yebo.
Bapela KO.
Yes.
Botes A.
Yes.
Benz Namashe Z. Sorry.
Ndiyavuma makahambe.
Earlier on, I had made a request to all of you that you either say yes or no. And it's yes or no, please. So that we finish quickly. Conclude, Kubeka, proceed, Honorable Member.
RN.
Yes.
Lomo SM.
Yes.
Gina N.
Yes.
Olomisa SP.
Yes.
Jeffrey JH.
Yes.
Kekana PS.
Yeah.
Mafu NN.
Yebo.
Mashalela AF.
Yes.
Mashobo MD.
Yes.
Majola FZ.
Yes.
Makwetla SP.
Yes.
Manamela KB.
Yes.
Mangu LN.
Yes.
Mapulane MP.
I vote yes.
Mashego Dlamini KC.
Yes.
Masondo D.
Yes.
Matale CC.
Yes.
Mahaule MR,
Yes.
Moloi BE,
Yes.
Morolong IK,
Yes.
Motaung NE,
Yes.
Kabane NP,
Yes.
Nzuza NB,
Yes.
Peters ED,
Yes.
Pilane Majake MCC,
Yes.
Squacha M,
Yes.
Soku MM,
Yes.
Swartz B,
Yes.
Tau MPF.
Yes.
Get that? The yes. Is it a yes?
Yes.
Yes, all right. Tolashe NG,
Yes.
Chabalala J.
Yes.
Did you hear that? Yeah. Chwete P.
Yes.
Abrahams, PN.
Yes.
Adams, RC.
Yes.
Adons, MG.
Yes.
April, HG.
Extemia.
Bukes, AJ.
Yes.
Bilankulu, JH.
Mapumela.
Bilankulu, NK.
I vote yes.
Bongo, PT, BT.
I vote yes.
Buthelezi, NS.
Yes.
Kapa, N.
Yes.
Chabane, MS.
Yes.
Dirego, DR.
Yes.
Dlamini, NE.
Yes.
Dlamini, BN.
Yes.
I did call it. Dlamini, NE.
Yes.
Dlamini, SM.
Yes.
Dlulane, BN.
Ewe.
Dunjwa, ML.
Ewe.
Gyangi, QR.
Yeah.
Gancho, N.
I vote yes.
Gela, A.
Yes.
Komba, MM.
Yes.
Gumbu, TT.
I vote yes.
Kumede, SN.
Yes.
Hadebe, BM.
Yes, sir.
Harvard, X.
Yes.
Hemmings, J.
Extemia.
Hemmings.
Extemia.
Hlongo, AS.
Yes.
Jacobs F.
Yes.
Jacobs KL.
Yes.
James TH. James TH. Kumalo FE.
Yes.
Kibi MT.
Yes.
Kurnov GW.
Yes.
Kotampeko
Yes.
ZA.
Yes.
Kubega NJ.
Yes.
Kula SM. Lihwase TI.
Yes.
Lisoma RMM.
Yes.
Letsi WT.
Yes.
Lubengo ML.
Yes.
Luzipho S.
Yebo.
Make JJ.
Yes.
Mabe BP.
Yes.
Malibeta MD.
Yes.
Magak KE.
Yes.
Magwanishe G.
Yes.
Mahambehlala T.
Yes.
Mahlaule MG.
Yes.
Mahlo NP.
Kialumela.
Maumapelo SOR.
Yes.
Mkhwebane Mashele LS.
Yes.
Mkhwebane Marilele PP. Yes. Malaji T.
Yes.
Malimeja CN.
Yes.
Malinga VT.
Yebo. Yes, Malinga VT, yes.
Malomane VP.
Yes.
Mamabulo JB.
I vote yes.
Mananiso JS.
Yes.
Mandela ZMD.
Ewe.
Maneli BM.
Yes.
Maneli ST.
Yes.
Manganye J. Marekwa GP.
Yes.
Maseko Jele NH.
Yes.
Masheko MR.
Yes.
Mashele TV.
Yes.
Masiko FA.
Yes.
Masondo TS.
Yes.
Masuwale GP. Masuwale GP. Okay. Masuta TM. Maswanganyi MJ.
Yes.
Matafa OM.
Yes.
Matebula EF.
Yes.
Matuba MM.
Yes.
Mbata SGN.
Yes.
Mbingo Gigaba BP.
Yes.
Mbuyane SH.
Yes.
McDonald EL.
Yes.
Mkhunu TVB. Yes. Mdabe SW.
Yes.
Mdakane MR.
Yes.
Mkhwebane T.
Yes.
Mjobo LN.
Yes.
Mkhatshwa NT.
Yes.
Mkhize ZL.
Yes.
Mkhwanazi JCN.
Yes.
Mlenzana Z.
I vote yes.
Memezi HMZ.
Yes.
Mutle TN.
Ketopila yes.
Muwache RM.
Yes.
Modise M.
Yes.
Modise PMB P. Modise PMP. Nuvo Drachen WS.
Yes.
Muela, DL.
Yes.
Mulala, LE.
Yes.
Mulegwa, MA.
Yes.
Monagedi, MD.
Yes.
Muruwane, ML.
Yes.
Muruai Chetla, PR.
Yes.
Mutapo, MRM.
Kiadumela.
Muteja, MS.
Yes.
Mpanza, TS.
Yes.
Mpumza, GG.
Yes.
Mpushe, PT.
Ewe.
Msimango, XN.
Yes.
Mtembu, AH.
Yebo.
Mvana, NQ.
Yes.
Mieni, ET.
Yes.
Miolwa, DJ.
Yes.
Ndaba, CN.
Yavuma.
Nkomo, Z.
Yes.
Nkosi, BS.
Yes.
Nontsele, M.
Yes.
North Nahal, J.
Yes.
Ngola, X.
I vote yes.
Ngola, X.
I vote yes.
Ntobongwana, N.
Yes.
Ntuli, MM.
I vote yes.
Ntwane, JC.
Yes.
Papo, AMH.
Yes.
Patrain, S. Peacock, NP.
I vote yes.
Pete, PA.
Yes.
Piri, CM.
I vote yes.
Peterson, ML.
I vote yes.
Pillay, KB.
Yes.
Kayiso, XS.
Yes.
Ramadwa, MM.
Yes.
Ramulobeng, A.
Yes.
Siabi, AM.
Yes.
Simenya, MR.
Yes.
Shabalala, LF. Shabalala, LF. Absent. Okay. Sibiya, DP.
I vote yes.
Sihloayi, NN.
Yes.
Siwela, BS.
Yes.
Siweya, RT.
Yes.
Yes.
Yes. It's a yes.
Skosana, GJ.
Yes.
Somyo, SS.
Yes.
Stock, DM.
Yes.
Klape, MME.
Yes.
Tlomelang, KB.
Kiadumela.
Tobias, TV.
Yes.
Tseki, MA.
Kiadumel.
Did you hear that? Yes, okay.
Kiadumel and de.
Chwete, B.
I vote yes.
Chobeka, Makeke, NP.
Yes.
Van Skalkwyt, SR.
I vote yes.
Volmarans MJ.
Yes.
Chaba NV.
I vote yes.
Chaba VC.
I vote yes.
Chaba Nchaba PP.
I vote yes.
Chasa FD.
Yes.
Chego ST.
Yes.
Yabo BS.
Yes.
Zibula BT.
Yes.
Zondi MA.
Yes.
Zuma AS.
I vote yes.
Zungu TRM.
I vote yes.
Zwane MJ. Zwane MJ.
I vote yes.
Steenhuisen, JH.
I vote yes.
Kwahube S.
I vote yes.
Lotrit A.
I vote yes.
Masango BS.
Yes.
Milham KJ.
I vote yes.
Gondwe MM.
I vote yes.
Van Minen BM.
I vote yes.
King CV.
Yes.
Nodada BB.
I vote yes.
Breitenbach G.
Ye-
You got that? Did you get it? Okay. Horn W.
Stem ja.
De Freitas MSF.
Vote yes.
Marais SJF.
Ja.
Kola D.
I vote yes.
Van der Walt D.
Ek stem ja.
Maglua JJ.
I vote yes.
Abrahams ALA.
Yes.
Alexandra WR.
Yes.
Bagraim M.
Yes.
Bason LJ.
Ja.
Bergman D.
Yes.
Bodlani T.
Yes.
Bond MS.
Yes.
Bryant DW.
Yes.
Kachalia GKY.
I vote yes.
Kado MJ.
Yes.
Chetty M.
I vote yes.
Clark MO.
I vote yes.
Cuthbert MJ. Cuthbert MJ. Okay. De Villiers JN. Engelbrecht J.
Ek stem ja.
Esak F.
I vote yes.
Faber WF. George DT.
Yes.
Golding BC.
I vote yes.
Graham SJ.
I vote yes.
Hicklin MB.
I vote yes.
Hussein MH.
Yes.
Hansinger CHH. Ismail H.
I vote yes.
Joseph D.
Extem ja.
Chachau KL.
I vote yes.
Kanyile TA.
I vote yes.
Kumalo NV.
I vote yes.
Kriya HCC.
Ja.
Krambok GR.
Yes.
Legov TA.
I vote yes.
Lees RA.
Jawohl, ma.
Lorima JRB.
Yes.
Mabena TB.
I vote yes.
Mabika MS.
Yes.
McPherson DW. Okay. Majola TR. Maladzi MS.
Yes.
Masipa NP. Okay, go back. Majola TR.
Yes.
Maladzi MS.
I vote yes.
Maray EJ.
Yes.
Masipa NP.
Extem ja.
Mazzone NWA.
I vote yes.
Mbabama TM.
I vote yes.
Mbele ZN.
I vote yes.
Mhlongo TW.
Yebo.
Mo SJ.
I vote yes.
PTL.
I vote yes.
Myberg NG.
Yes.
Ngobo S.
Yes.
Opperman G.
Extem ja.
Phillips C.
I vote yes.
Powell EL.
I vote yes.
Rose AC.
I vote yes.
Sarupen AN.
I vote yes.
Schreiber LA.
Ja.
Seitlolo LS.
I vote yes.
Sharif NK.
I vote yes.
Shalembe ML.
Yebo.
Small JF.
Stem ja.
Spies ERJ.
Extem ja.
Stube DJ. Or Stabe DJ. Yes. Absent. Okay. Te Blanche OS.
Ja.
Van Dijk V.
Ja.
Van Zeel AM.
Ja.
Walters TCR.
Yes.
Weber AMM.
Yes.
Whitfield AG.
I vote yes.
Winkler HS.
I vote yes.
Malema JS.
Absent. Shivambu, NF.
It's no. Absolutely no.
Mende, NV.
A definite no. Mama kuyabanda sicela kunyuke into eshushu.
Dlamini, MM. Absent? Okay, absent. Maotwe, OMC.
No.
Ndlozi, MQ.
No.
Mashabela, NR.
Absent.
Mkalipi, HO.
No.
Tlangweni, EN.
Extemnia.
Aris, LH.
Abeslistenia.
Peza, K.
I vote no.
Chirwa, NN. Chirwa, NN.
Absent.
Hlonyana, KNF.
No.
Kaula, MS.
Cha, angivumi.
Koza, AV. Deko. Absent. Komane, RN.
Definite no.
Madlingozi, BS.
No.
Mafanya, WTI.
No.
Makamba Pocha,
No. It's a no.
Makesini, M.
And you?
Makesini,
No.
Mani, M.
No to cruelty.
Marei, P.
Yeah.
Matulelwa, B.
I vote no.
Matias, NS.
I vote no.
Matumba, A.
Ndikohama.
Okay. Mhlongo, N. Okay. Mkondo, CN.
No.
Mohale, T.
No.
Mohlala, MR.
No.
Mudwendi, MK.
No.
Msane, TP.
No.
Mtetwa, E.
No.
Noluchungu, NJ.
No.
Pambo, V. Absent. Okay. Paulsen, MZ.
Extemnia.
Sikwambana, M.
No.
Siwisa, AM.
No.
Sondi, NP.
No.
Tambo, S.
No.
Tijana, Y. Absent. Tembekwayo, SS.
No.
Tito, LF.
No.
Yako, YN.
Sing, N.
Yes.
Majozi, Z.
Yes.
Buthelezi, EM. Buthelezi, SA. Ebekhulu, RN. Hlengwa, MD. Hlengwa, MD. Hlengwa, M. Hlengwa, MD.
Yes.
Sengwa M. Okay. Lutuli BN. Msimang City.
Yes.
Ngobo SL. Sitole KP.
Yes.
Van der Merwe LL. Zondo SS.
Groenewald BJ. PJ.
Ek stem ja.
Mulder CP.
Yes.
Vessels WW.
Ek stem ja.
Boshoff WJ.
Ja.
Breert T.
Ja.
Denner H.
Ja.
Groenewald IM.
Ek stem ja.
May P.
Absent.
Absent. Mulder FJ.
Ek stem ja. Okay.
Yes. Van Staden PA.
Ek stem ja.
Meshwe KRJ.
Yes.
Swart SN.
Yes.
Sukas ME.
Yes.
Thring WM.
Yes.
Holomisa BH.
No.
Kwangwa NLS.
Kwangwa. Aye.
Mahau TL.
A big no to an African woman.
Zungula V.
No.
Dilil P.
Yes.
Heron BN. Heron B.
Yes.
Sheikh Imam.
Yes.
CBC CHM. CBC absent. Gallo MP. Gallo MP.
Okay.
Jafta SM.
Okay.
No.
Lekota
abstain.
MTP.
Abstain.
Abstain. Lower T.
Yes.
What? Lower T.
Yes.
Yes. Nyonso.
No.
Nyonso.
No.
What is the point of order?
Speaker, I want to call a point of order, but Mtatelo Kota, who is he leading?
Hi, man, that's not a point of
Who
order.
is he leading? Umahamba yedwa.
It's not a point of order, man.
Nyonso M. Sorry, sir.
No.
No. Hendricks, MGA.
No.
Hendricks, MGA.
No.
Honorable members, as I indicated earlier, members who remained present.
Speaker, Mhlongo, I want to, earlier on, when I tried to get the mic, but it was not given to me.
All
So
right,
can my
yes.
vote be recorded as
Yes.
a big no?
Okay, thank you very much. So as I indicated earlier on, those who remained present but could not when called
Just want to verify.
may now raise their
Madam
hands.
Speaker, we just want to check. Is that
Mhlongo.
we want to hear, please, if you could pass the mic.
Mhlongo, NM.
Are there any other members who did not cast their vote who are in the house? Mama Kaula uphakamisa isandla or what? Hayi man ungenzi njalo man. Okay, honorable members, the voting session is now closed. The voting session is now closed. So we will await the results from the team. Honorable members, whilst we are waiting for the results, earlier in the debate, the Honorable Wolomisa, General Wolomisa, at the end of his speech, handed to the Secretariat an envelope which appears to contain documents. As I sit here, I would not know the type of information contained in the envelope and how it was obtained. I will therefore accordingly obtain legal and procedural advice on the matter to enable me to decide what to do with the information. In doing so, order, Sissy, please, order. In doing so, I will have regard also to Section 58 of the Constitution, which provides for privileges and immunities of member. I thank you, honorable members. Are the results ready? Is there a hand? Yes? Honorable Mkhalipi?
I've been bullies.
Hi, man, General. Up. Also, I've asked them to increase the temperature. Thank you. Order, honorable members. The results of the division is as follows. Yes, 318. Noes, 43. Abstention, 1. The question is agreed to, and Advocate B. Mkhwebane is accordingly removed from the office of the Public Protector, according to the recommendation of this House. Thank you very much, honorable members. Honorable members, that concludes everything and the House is adjourned.